11 bills to vote on. And we'll just go in sequential order. We'll start off with Senate Bill 13. That's Jamie.
Senate Bill 13 alters the existing formula for allocating grants from the Vehicle Theft Prevention Fund, which is administered by the Vehicle Theft Prevention Council. Under the bill, to the extent practicable, the Vehicle Theft Prevention Council is required to allocate grants among the subdivisions of the state on a pro rata basis determined by the number of motor vehicle thefts in a subdivision divided by the total population of that subdivision and then multiplied by 100,000, rather than the existing formula, which requires the allocation to be on the basis of the total number of vehicles registered in each subdivision divided by the total number of vehicles registered in the state. There is an amendment in your packet from the sponsor, and it would change language on page 2 of the bill to instead require, and I'll just read the new language. It would now read, to the extent practicable, the council should consider allocating grants made under this subtitle among the subdivisions of the state on a pro rata basis determined by the total number of vehicles stolen in each subdivision divided by the total number of vehicles stolen in the state. Just as a technical note, that word should in line 7 of the reprint should probably actually just be a shall. And I
That's fine.
yeah.
Down, I mean, it's a factor now. They're just going to consider it. It's not a, they have to reallocate the money
Right.
based on this, in your fiscal note with the chart. So it's better for the counties that are, you know, all right. Senator Kessley.
So JPR, we don't usually get spending bills, and maybe there's a reason for that, because I don't know how they do this on the committees that get spending bills or funding bills, but this will take money away from my county. I'm not going to vote for something that takes money away from my county. So maybe we shouldn't have a bill on funding, and maybe those committees are allocated more geographically or something. They don't consider it as much in this committee. So that's all I got. Thanks.
I mean, I guess with the amendment, it's not a certainty under the bill, but it's a high probability because it's going to be based on the number of cars that are actually stolen. But can we adopt the amendment first and then talk about the bill? Sorry, can we just adopt the amendment real quick? Everyone okay with that? Okay, we can discuss the bills amended. Go, Senator Bailey.
So I have to agree with my colleague. I think that this directly has the ability to penalize jurisdictions that are doing a good job, right? We got thefts down. We've got these people, well, we're going to take money from one and give it to another or not allow them to compete. I think that there's a chance, and I think if the amendment it should say may, not should consider, right? If you really wanted to be transparent and say, well, it could be used in another area.
The question is there a legal difference between should and may?
May would be that they have the ability to consider it. Should is an uncertain term as it is. It's just saying that it's more of a suggestion.
But the amendment changes it to shall. No, I thought the amendment should.
Well,
He amended the amendment.
That was my technical recommendation was that typically in the code you don't see the word should.
This amendment here is not correct.
It just changes the word should to shall. Right. That he's making that inline change right now.
Which is a pretty difference.
Who's making that? The sponsor? Or Jamie is?
I made it.
You're
That's my
making it.
amendment, yeah.
Okay.
So,
All right, I understand. Okay.
Senator West.
There's a big difference between may and shall, to answer Senator Bailey's question. There's less. No. Well, there are three possibilities. There's should, which is in between. There's may, which is totally permissive. And there's shall, under Senator Smith's proposed amendment. And so there's not too much of a difference between may and should. There's a massive difference between may and shall.
All right,
So we adopted the amendment?
we did.
Whoops. Did we drop your amendment?
Yes, the shall, it's a shall.
I would prefer not to have done that.
So, we could roll it. Any further discussion? All right, so I'll make a motion for a favorable
Second.
with amendment. It's been seconded. We'll do a roll call.
Vice Chair Wadsworth.
Yes.
Senator Lee.
Yes.
Senator Castleton.
No.
Senator Huddleman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
No.
Senator Huff.
Just to reconfirm, the language is shall consider. So this isn't even actually changing the formula, so I'm fine with that, yes.
Chairman Smith.
Yes. Senate Bill 17. That's Heather.
This bill requires that,
Okay. No, I just had a question because I wasn't following the argument of how this would take any funding away from another jurisdiction.
It's not, the bill reallocates it based on the actual number, the theft, the actual numbers of vehicle thefts in your jurisdiction. So right now, if you look at on the fiscal note on page 3, it kind of shows you the current breakdown.
So the Vehicle Theft Prevention Fund already exists?
Correct.
Okay, that's what I
Yes.
missed. Thank you.
Okay, Heather.
so Senate Bill 17, there are two amendments in your packet. This bill requires the judiciary, in consultation with domestic violence and child abuse organizations, to develop a training program for judges presiding over child custody cases involving child abuse or domestic violence. The bill specifies what topics must be in the training program and the qualifications for an entity providing the training. The bill also specifies the training hour requirement for the judges and requires the judiciary to report the names of a judge who does not comply with the bill's training requirements to the Commissioner on Judicial Disabilities. For the two amendments in your packet, the first one, which is ending in 325, this removes parental alienation from the list of required topics the training must include. The other amendment in your packet, 828, defines terms including child abuse and domestic violence, and it also alters the requirements for an organization or entity that's providing the training under the bill.
Yes, very quickly, there have been horror stories of judges who really were not trained in how to detect problems with child abuse, assigning children to the custody of someone who abused them, and in some cases killed them. So this requires that judges who are going to be sitting in those sorts of cases have some training in how to detect the problem and therefore react properly to the situation. The key to the bill, as far as I'm concerned, is the bill does not require in-person training. So it's 20 hours in a year up front in the first year, and only modest amount of training in subsequent years. And the 20 hours can be online. So if you figured there are 52 weeks a year, 20 hours, that means every 2.5 weeks, the judge would have to go online and take 1 hour worth of training. So it's not overly onerous, and if it saves children, it's time well spent by the judges.
All right, can we go ahead and, if there's discussion on the amendments, if we'd like to adopt the amendments, we could just discuss the bill as amended. So, the motion to adopt the amendment, is everyone okay with doing that?
Both
All right, both amendments, rather. Thanks. Further discussion?
I mean, just my only quick thought, look at these amendments. I do have some pause on this because I do worry about, but the hearing was compelling, but I do have some pause about the judiciary, us doing their trainings or mandating it. But it still, even this amendment, it's pretty broad. I mean, they were talking about child abuse, things like this, and you've got things on implicit bias. You've got things on limitations of local departments of social service investigating. I mean, I mean, you've got a lot of stuff in here.
Well, it's, 20 hours of training total, so, and you're right, there is a lot of stuff, but that's why there's 20 hours of training. If you had it much less than that, you could not train on all the elements that the judges ought to be trained on. I just don't think it's, again, you got 52 weeks in a year, 20 hours of training. That's 1 hour every 2.5 weeks. We're not talking about a huge burden with we're placing on the judges. They can do it at home. They can do it on weekends. They don't have to do it during the workday. And again, if it saves a couple of child's lives, it's time well spent. That's my view.
So my biggest concern on the bill is that we specify who the qualifications of people that must do the training. And those qualifications mean that you're getting people who are advocates in this particular area. That's who would meet those bills, people who are advocates. Generally, judiciary's training stays away from advocates. They're trained by people who are knowledgeable, attorneys who practice or the like, professors, law professors. So I think it puts the judiciary in an uncomfortable position of allowing advocates for a particular side of an issue to have sort of unfettered time there to push their issues. Not that, I mean, these are tough stuff, and you want judges to have knowledge in these things. They're really tough cases, but the judiciary generally strives to have a balanced approach, and I think that would be a challenge for them under this bill. Thank you.
Thank you, Mr. Chair. The second of the two amendments, I think it specifically addresses that. It says, an individual trainer or organization providing training on child abuse under subsection C shall possess or have personnel possessing at least 5 years' experience in directly assisting abuse survivors engaged in custody litigation, including cases involving child abuse, or at least 5 years' professional experience in providing expert assessment, protection, and treatment to survivors of child abuse. So nothing in here is about advocates. These are people who have lots of experience in this area who are going to be doing the training.
So I would say that I support the bill. I was very compelled by the hearing when we're talking about advocacy for children, that I know when this comes up, being a policeman, we got training Whenever there was a decision or there was something that was different, we were trained. Teachers are trained. I think that clearly some of the examples that they made showed that that the judges should receive that training. And I think 20 hours a week, it's only a few days, 20 hours a year, that's a few days of training. And from what they said in the hearing, that most of our states surrounding us, the judges are trained and the federal judges are trained. And Maryland felt that they didn't need it, and I'm going to vote for the bill.
Okay. Can you hear me now? I agree with Senator Bailey. And also, I just wanted to add that this was the recommendations and product of the work group. And the work group worked very hard on these, and they considered everything. And I think that about over 61% of the cases, the judges are before or dealing with family law issues such as this. But we have found that sometimes they lack understanding of these critical issues that come before them, especially dealing with child custody cases, dealing with domestic violence. And I think that this will make for a better judiciary. And I don't think it's that overburdened because it's only 20 hours. And so I am supporting the bill.
All right, further discussion? All right, make a motion?
So moved.
All right, so we'll do a roll call.
Favorable with amendments.
Favorable with amendments.
Vice Chair Wabstriker.
Yes.
Senator Lee.
Yes.
Senator Castley.
No.
Senator Huddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes. Bill passes with the amendments. Okay. Let's go on to Senator West, Senate Bill 36. So Josh.
This emergency bill is a follow-up to Chapter 686 of 2021, which authorized the remote execution of wills. That bill required that a remotely executed will be notarized. However, the notary statute expressly prohibits the remote notarization of wills. So what the bill does is twofold. First, it removes that prohibition in the notary statute, and second, it provides a second option for remote execution of wills, which doesn't require notarization. But in such a case, the supervising attorney would not be allowed to also serve as a witness to the will.
Thank you, Mr. Chair. So I know Senator Castley has had and has problems with remote notarizations of wills, but that issue was answered last year. We passed the bill that authorized remote notarization of wills, not only during the pandemic where it was absolutely essential, but ongoing. And when you think about it, if there's an older lady who's in a nursing home and is not in a condition to travel, it's important that she be able to make her will remotely with the lawyer down in the lawyer's office and the witnesses, et cetera. So we did that last year. That is not this bill. All this bill says is that whereas under previous circumstances, one of the three witnesses had to be a notary public, under this bill, you still have to have the three witnesses, but one of them does not have to be a notary public. It can be an independent person. So under current circumstances, you could have the attorney, an independent person who's a witness, and a notary public. Under this bill, you can have the attorney and two independent people who are witnesses without a notary public. That's all this does. It eliminates the need to have a notary public sitting there at the time the will is signed. I'm sorry. No, there are no amendments on this one.
I'm the one without the hair. I'm trying to, currently the notary public under the current law does it matter where they are? I'm trying to look at the existing law.
So, the way that the remote execution of wills bill worked last year is that there had to be a notary involved. They did not have to be in the same spot. However, the problem that the advocates identified is that the notary statute, which you actually see, I think, on the second to last page of the bill, expressly prohibits the remote notarization of wills. So the testimony was that essentially nobody was able to do a remote execution of a will because the notary was not allowed to notarize the will unless everybody was present in the same location.
Yeah, so we really didn't cross this bridge last year because somebody had to be there with the testator, right?
I think it would be accurate to say the General Assembly attempted to do that, and it simply didn't function because there was, frankly, an oversight that they thought it would. I think the notary requirement was added while it was in committee to address some of the concerns about the authenticity, but I think there was just a failure to recognize that the notary statute contained this prohibition, which prevented that from actually functioning.
Yeah, okay, thank you. I'm going to vote against the bill just because I find with having no one present with the testator, the lawyers doesn't matter if they're there or not. Currently, only people that have to be there are the witnesses, and typically what happens is you use a couple of nurses, you use the janitor and the nurse, you use someone who's visiting somebody else, two people visiting somebody else. They don't have to know the testator, they just have to be people who are competent and can say, yes, that is the testator. And all they're really attesting to is that I saw this person, nobody had a gun to them, I talked to her, she seemed alert, she understood what she was doing, she was not comatose, I watched her sign it. That's all they verify. And I don't think it's too hard to get those people in the room for signing a will. So just in the interest of trying to avoid will disputes, I'm going to oppose it. Thank you.
I'm overriding you. Sorry, I'll just let you, you're in control now. I'm the captain now. Think of the good old days. We were on camera on voting sessions. You just hit your button. So it's a dispute then, I mean, Senator Castley or council can help me then, is that the notary will not be there to sign off. That's your concern, is that the notary won't be there in person to sign off on it then?
I just want somebody. All these people, the lawyer, the two witnesses, the notary, we're cutting out the notary. I just wanted somebody to be there with the testator in the room, at least one person in the room, so I can call them as a witness to say, what did you see? What did you see? When you walked, if you have a will contest as a lawyer, I would find those witnesses, they have to put their name and address on the will. I would subpoena them, I bring them in. What, you got to the house, who answered the door? Who was there? What'd you see when you got in the house? Who let you in? Where'd you go? What room were you in? When you got there, what did the room look like? Was it disheveled? You saw the person. How long did you just see them? Did they say anything? Did they remark? Did they read the will? Did you see them read the will? What was their skin color like? Did they look like?
But you're still going to have witnesses under this, right, that sign it? But your argument is there could be somebody there that's...
No, under this, the witnesses are on video. In this bill, they're only there on the video.
They're not physically there with the person?
No, they're all on video. So it comes up, the testator is on video, everybody else is on their own video outside the testator, boom, testator, is this your will? That kind of stuff.
So when we did last year, and I actually used it because we did a refinance, we did it, and we did it all electronic now, and I think that was because of the bill that we did. And I'm pretty sure, obviously, who's the counsel on this one? Josh, sorry. So when we did it, I'm sure it required, it was crazy. You could do it all. You do your whole mortgage now on your phone, it's now. So, and there was nothing notarized, anything like that. Obviously, mortgage fraud is a huge crime. I think we had to have a witness on it, though. Isn't that, when that we required, we changed all the law for mortgage documents, things like that. We allowed it to all go electronic.
So I'm not sure about the mortgage stuff, but what the General Assembly did with the wills is it requires basically an attestation in the bill last year, it had to be by the notary public, which attested to, the idea that was all voluntary It would be prepared by an attorney and signed off on by a notary.
So, and this was, Senator Cassidy, this was your, basically, this was our compromise last year, was it not? You were worried about this notary provision, and we stuck it in there, and this takes it out.
So what it does, it leaves, essentially, what the bill last year did is say, you need the supervising attorney to prepare this attestation, which is notarized and signed by 2 witnesses, one of whom can be the supervising attorney. So that procedure remains in law. There's simply a second option whereby it's not notarized and it's still prepared by a supervising attorney and signed by 2 witnesses, but the supervising attorney is not allowed to also serve as a witness in that case.
And there's no notary, well,
These are on screen.
why
The
not?
attorney's on screen and the testator's on screen.
But even when you do like a loan document now, you do it all here electronically, you're signing everything, but you still have somebody come and, well, imagine don't we still require mortgages and stuff to be notarized?
I don't know about that, Senator.
I mean, I don't know, this is like,
We did an electronic notarization statute last year.
yeah, so that they electronically notarize it, but this, we totally removed the notary from it.
Yeah.
I mean, that kind of strikes me as a big deal, because in Maryland, that's why we have the notaries for these official documents, to totally remove a notary from these.
You made the other argument that notaries find anywhere. Qualify, I mean,
Yeah,
you made the counter argument.
Most wills,
I know,
a notary otherwise is not required for a will. You just have to have 2
Okay.
witnesses who are not beneficiaries under the will.
and you're worried because they're on video now then and not in
I'm
person.
worried because they are just on, people just are on video, and we. I'm sorry?
So, at the risk of disagreeing with some of what's been said so far, the existing law, under the existing law, which is on page 3 of the bill and hasn't been changed, the undersigned attorney it's complicated language. I guess that's the best answer. If Senators Casserly and Huff would like to hold this bill, I will get the representative of the Estates and Trust section who deals with these issues every day to come in and patiently answer your questions. I'm prepared to vote on the bill, but if this is a matter of serious concern, we can hold it for another week, and I will get the person who really knows her stuff, because she signs wills daily, to come in and answer your questions.
Yeah, let's do that. If she can come in on Wednesday. Wednesday, it's 11 o'clock. 11 o'clock on Wednesday. One.
So Senate Bill 71 provides that a person who is the victim of an act that would constitute a violation of a hate crime may bring a civil action against the person who commits the act. Do you want me to orally go over them?
We'll enter in the amendments right now. We can discuss the amendments. We can outline the problem because.
Sure. Yeah, so there are 2 separate amendments. It's not in your packet, but I'm going to orally go over it. One of the issues that was noticed by members was the issue of standing, what victims would be able to bring a claim under this act or under this bill. The proposal is to treat standing under this bill like standing in a public nuisance case. So in a public nuisance case, in order for a private citizen to bring a claim, they need to establish that they have suffered a special injury, because generally the only parties that can bring a public nuisance claim is a governmental entity. So in Maryland, to establish a special injury, the plaintiff needs to show that they suffered a harm different in kind from that suffered by other members of the public. Maryland has also taken the same approach with respect to zoning ordinances. For a private citizen challenging a zoning, case law in Maryland states that they follow the public nuisance issue of standing. So the proposal here would be to simply in subsection A, add the language that the victim, so the person must be a victim of the act and also suffer a harm of a different kind from that suffered by other members of the public. And that would get to standing.
To the details, but I know you sent me the cases, but just can you explain to the committee where the case law and just a brief summary of facts of like why this would work and where this is grounded, because we don't have this in statute. Can you just explain?
Sure. So in case law, the courts have noted that it is a very fact-specific issue of whether an individual has standing. So there is, the two cases that I reviewed were from 2015, 2013, so they are recent. For example, in one of the cases, a union blocked traffic on a public road in front of a store, causing a traffic jam. So members of the public who were stuck in that jam had to use the private road and parking lot of the store to go around the traffic jam. So the store was suing for an injunction under a public nuisance cause of action. The court found that the store did have standing to challenge it because everybody was affected. All the members of the public were affected by the traffic jam, but the store was specially affected because their parking lot was blocked. Customers couldn't get in and out of the store. So therefore, they suffered a harm of a different kind from those suffered by the members of the general public who were stuck in a traffic jam. Another example, which I think is pretty relevant to this bill, was Ray v. Mayor of Baltimore about two members of the public challenging a planned development. So they were about a half a mile away from the planned development, and they argued that the court should have compared their aggrievement to the aggrievement of a person outside of their neighborhoods. So the court rejected that argument and stated that you can't assume that every single person in a neighborhood is automatically aggrieved. The court needs to examine whether the people inside the neighborhood are in fact specially aggrieved and could include people who aren't aggrieved. I think that's relevant for this bill in particular because of the language, members of the general public. You could have members who are members of the race, ethnicity, religion that is aggrieved, but simply being a member of that group doesn't mean that you are specially aggrieved. You still need to do the court's analysis under Ray v. Mayor of Baltimore about you particularly as a person compared to everybody else.
So, Senator Castle, go ahead.
Is this standing language, and I think, and we're on the right track with it, but this is like consistent with standing language that we see in other statutes then, that we're trying to narrow this down? And the whole idea is that we want people who are actually personally aggrieved. As we use the example, if the swastika was painted on my house, I'm the plaintiff, and the general neighborhood is not a plaintiff, it's me. It was on my house, I'm specially aggrieved. And even though I have 3 neighbors who might be aggrieved by this, I'm the only plaintiff in that case. Is this sufficient this standing sufficient to narrow that down?
A neighbor could potentially bring an argument. They would have to show a reason why that they are special against all the other neighbors. I don't know. It would be very fact specific, so I can't think of how they would articulate that argument.
Right.
But the court, it would go under, probably the defendant would file summary judgment to dismiss the claim. It would be a lot harder for them to make that argument, though. I don't know how.
As long as you're using the standing language, if that's where we're going.
Yeah, so this is the language based on the restatement second of torts that Maryland has adopted for public nuisance.
I'm good with that. Thank you.
So
So I think in the example that you give, if I'm a Holocaust survivor and I live down the street from your house that has the swastika on it, I could see that being one of those, it affects me in a particular way, perhaps?
Nope.
I don't. Or not, I mean,
Has to be the damage to your house.
well, no, because it's a public nuisance. I mean, I think it's unique. I don't know, I'm just throwing that out there as an example.
That's what we talked through the example,
Right.
and the answer I was given was it was damage to your house. You were the person that the swastika spray painted in your house, not the, not everyone that drives by can create a cause of action. That's my
Right.
understanding.
But I,
She's giving it more nuance, but I still don't think that's the case, but go ahead, go
So
ahead.
it's, yeah, I think it's going to be fact-specific, and
Right.
so I don't have a legal answer to the question, but I don't think it's the damage to a physical object
right,
that's triggering the harm here. So just to take your hypo, I think your hypo is probably out of the law, but like, let's say the swastika was drawn on my house, but specifically to offend my Holocaust survivor neighbor. In other words, it's drawn on my house because his bedroom overlooks the swastika. I think that, it's like, then you would have it. If it's designed to offend a specific person, and then that person is harmed by that, then I think that counts. But, I get that we're in hypothetical world, but if you're
Then you
5
have to-
doors down and it wasn't specifically designed to offend you or harass you or intimidate you,
yeah.
then I don't think you come into this as written.
I don't know. I mean, if let's say you're in a generally non-Jewish neighborhood, right? But your neighbor is Jewish and is a Holocaust survivor, and I guess you'd have to show that there was intent to try to, or no, to.
Most of your tort actions are required. I mean, just because I didn't know you were a Holocaust survivor, I was painting swastikas, and by just dumb luck, I put it on. I don't have to show an intent to offend the house. That was a violation, so it's so fact specific, and a judge
Yeah.
could let certain things
Right,
in.
right.
It's just, the whole idea of standing is that you don't want me to be able to just sue on anything. Oh, I don't
Right.
like that, I don't like that, I don't like that. It's
Right.
let's take the universe of potential plaintiffs to a manageable level so that the courts don't get
Right.
overrun.
I think this does that.
Could we have the amendment read one more time?
More nuanced, that is a much more, you're right. Go, Senator West.
Could we have the amendment read to us one more time?
Yes.
Sorry, yes. So it's the language pulled from restatement second of torts, that the person, one, they're a victim of the act, and two, suffered a harm different in kind from that suffered by other members of the public. And then the other amendment that was discussed, Senator Castley noted on page 2 of the bill, line 26. This is going to punitive damages instead of may be equal to 3 times, to change the equal to up to, so maybe up to 3 times.
All right, the adoption. All right. Before we, if there is no further discussion before we cast a vote, I had this bill when I was in I think my first year in the Senate, and it's been around for a long time. We've never been able to get to this point. It's a very, very elegant solution, and I just want to give shout out to Heather, because is really, really good work. That's good stuff. So, yes, Senator Lee.
As a sponsor?
Sorry. Sorry, go ahead. Yep.
Yeah, I want to be added on as a sponsor, amended.
Yeah, Senator Lee, I want to be added on as sponsor too. How about that? There you go. Everyone, West, Hellman,
Lee,
Watson. All right, there you go. Is everyone okay with adopting that amendment? See, the names on it. All right. Do we need to do a roll call, or is everyone good? Motions for favorable, it's been seconded.
Favorable with amendments.
With amendments? Everyone's good? All right. Everyone's favorable, great. All right, so I think Senate Bill 74 is being held just because we don't have a letter from B&T for the fiscal impact. So then we will move on to Senate Bill 97.
So with Senate Bill 97, there is an amendment in your packet. So this bill repeals the penalty for a circuit clerk for a county who fails to execute a bond or take the oath to accept their position. The bill also requires the clerk of a circuit court to coordinate with the comptroller to provide the comptroller certain information about the application for bank licenses and account of licenses. The changes that appear on page 3 of the bill, those two sections, so that would be section 2-211 and 2-212, are removed from the bill, so there's no change to those sections.
Was there, just behind the bill, the reason for doing this, was there like some, I'm just not, I mean, I see what it does, I'm like, why are we doing that?
I don't know. It does offer more flexibility. So instead of being specific about providing this information by certain timelines, it just says to coordinate with the comptroller.
Again, there was no opposition by the courts or the clerks or anything, right?
I
mean,
don't believe so, no.
Yeah, I don't see any opposition. Okay, all right, thank you.
Adopt the amendments. Cool. Is everyone okay adopting amendments? All right, great. Further discussion? All right, motion is for a favorable with amendments. Been seconded. Do you need to do a roll call, or you want to just, is everyone okay? Is everyone okay? All right. Bill passes with amendment. All right, we are going to hold Senate Bill 151,
You skipped 125.
but we'll go to 125, sorry. Senate Bill 125.
This bill authorizes a non-stock or religious corporation that files articles of revival online with the State Department of Assessments and Taxation to file only the 7 most recently due annual reports required to be filed, rather than all past due annual reports.
Discussion. Senator West. Say what?
It makes, nonprofit organizations frequently do not have records going back more than 7 years. I'm not sure I would have required 7 years, but certainly making them go back 12 years, 15, 25 years is impossible for most organizations. This is just a practical bill.
I mean,
Should we amend the 7 to 5?
whatever you want to do.
I don't know if there's a practical reason for 7. It's not.
Why did they pick 7, I'm just wondering? Do you remember?
Magic number, is you're supposed to keep tax returns for 7 years.
Is that right?
I think so.
That's what isn't that like the audit rules or whatever, is how far you should keep stuff back is 7 years? That's what I
Didn't know
always
that.
heard.
Got it. All right. Senator Sidnall.
Just a question, does anyone remember any testimony as to why these had to be done online? What says, and past due annual reports online is required?
I don't think there was any testimony on that point, but you're correct. It only applies if you're doing this, filing this online as opposed to in paper copy. I mean, I think the bill was crafted with the input of SDAT, so it may have been their preference that people do this online, I'm not sure.
On both ends if you do it that way, but. I don't know, and I mean, honestly, I don't want, I mean, you could hold it and we can make that inquiry, I just don't know. Yeah. I mean, they're trying to get you to be more efficient on both sides, but. I mean, All right. Now I'm curious now, I wanna know. Yeah, I know, because it's more efficient, yeah.
If you don't do it online, you gotta do 12 years. But
Yeah.
if you go online, it's
Yeah,
just,
you give me 7. All right, motions for favorable.
Second.
It's been seconded. Is everyone okay? All right. All right, now we're on Senate Bill 151, which we will just hold, because I don't want it, the sponsor's not here, so I don't want it. So Senate Bill 232, again, I think we're holding because we're waiting for B&T? Okay. And then, so now we'll go on to Senate Bill 261.
So this bill specifies that transfers of interests in partnerships and limited liability companies on death pursuant to the terms of the operating agreements of those entities are effective according to the agreements and are not to be considered testamentary and thus subject to the requirements of wills. The bill would apply to all LLCs and partnerships whose agreements are in effect on the bill's effective date. There is an amendment in your packet. That's number 653022/1. This simply tweaks some of the language in the bill so that references to partnership interests are simply worded consistently throughout the bill.
This is really actually very important. There are literally tens of thousands of partnership agreements and LLC operating agreements out there that have been drafted over decades. And virtually every single one of them contains a provision in there providing for what happens to the partnership interest or the LLC membership interest if the member or the partner dies. They all contain provisions like that. And the partners and the members expect to use those provisions. So what this Court of Appeals decision said last summer was because unless a partnership agreement or an LLC operating agreement is executed like a will, currently with a notary and 2 witnesses, unless that happens, these agreements are non-functional. They will not be observed, and the interest will pass to the estate of the person who dies and create all kinds of problems to partnership agreements and LLCs all across the state. So this basically says, that what this bill says is that the decision last summer of the Court of Appeals is overruled, and partnership agreements and LLC operating agreements will be effective even though they were not executed like wills. That's what this bill says. And thereby validates retroactively tens of thousands of legal documents that have been executed around the state. It's a very important bill. Boring, but important.
The backstory to this bill is actually very, very funny, but.
I said boring.
your enthusiasm doesn't change.
But the backstory is not boring. We'll get into that later. All right. So, no amendments on this, right? There are? Oh, yeah, sorry. All right. Sorry, that you read the inline amendment. Can we motion to adopt? Is everyone okay? All right. Further discussion? All right, now bills before you as amended, motions for favorable. It's been seconded. Everyone's okay? Awesome. All right, Senate Bill, it's Heather, right? Senate Bill 341.
We have to hold that, right?
Do we have to hold this?
No, we don't.
Yeah. So this is Caroline County State's Attorney and Sheriff's salaries. So the bill alters the annual salaries for these positions. So the salary of the state's attorney is equal to 85% of the salary of the district court judge, and the salary of the sheriff is equal to 85% of the salary for the state's attorney. There was a letter that was part of the written testimony by the sponsor stating that it has the support of the Caroline County senators. Not this one, it's a local, yeah, it only increases.
He's been on, I think he's testified almost every other day of session.
Well, he's this year's head of the state Supreme.
That's right.
It's a rotating.
Wait, I thought it was Richard Gibson. But he's the one, the Annapolis person?
You might be their legislator.
Got it. All right. Further discussion? Motions for a favorable?
Second.
Seconded. Everyone's okay?
Yeah.
Excellent. Okay. So just for the, we've held 74 because we're just awaiting confirmation from B&T. We held
You held 36.
36 just to get some more information to work on. So I think next week we'll work on that. And then what else did we hold? We held 151 for being 151 because sponsor's not here. And then 232 for B&T. So,
Good week.
all right. That concludes the voting session for today. See you all next week.